Thank you. We will, so my colleague Thalia and I will jointly do the presentation. Thank you so much for the introductions. But my colleague Thalia will start first, and we will have a PowerPoint presentation as we will be talking about some specific cases, and there's a lot of law. So I first leave the floor to my colleague Thalia.
Thank you very much. Can you see our slides? Yes, thank you, Dana. And can you hear us clearly? Can the interpreters hear us clearly?
Yeah. Yes, we can hear you.
Okay, thank you very much. Right. So what we were looking at today is two cases, specifically two cases that were in the Belgian courts, and both of them were about arms or other trade and relations to Israel. And the two cases had very different outcomes. We could say even almost contradictory outcomes. So what we wanted to look at today is exactly what those cases did, what the applicants said, and what the outcomes were, and perhaps try to seek what we can learn from these judgments in the sense of how international law was used and how it came to these specific conclusions. So these are the two of them. They're both by the Court of First Instance of Brussels, but Brussels is divided into two different sets of courts, namely the Dutch ones and the French ones. Okay, so both of them were summary proceedings. The first one was specifically a very urgent procedure because it was concerning a vessel that was at that moment in the harbor in Antwerp and carrying ball bearings, a kind of tapered roll bearings. I'm not very technically talented, but these would be used in military vehicles by Ashot Eshkelon, and they produce Merkava tanks and Neymar armored vehicles, and we know that both of these tanks and vehicles have been used in Gaza. The goods were passing through Belgium as they were coming from France up to the port in Antwerp, and they were going to leave to Israel, to the port of Ashdod from there. The company from France called Timken has also been shown to have specific links with the arms that were used in Gaza. The second case was also a summary proceeding. It was also brought by NGOs, but in this case, there were also two individuals that were co-plaintiffs. So this case was against the Belgian state, where the previous one was against the Flemish community. I'll explain in a bit why in the first one that was the case. So the second one was also about the transfer of arms, and more broadly, a trade ban, and also about the termination of the association agreement that the EU and the member states have with Israel. So it was about active and passive cooperation with Israel. It was a much broader set of legal arguments than the first one. So I will explain the first one, and Gamze will then turn to the second one and also explain the lessons that we think we can draw from these cases. Okay, so the first one, the specific wordings of the court were quite interesting. When at the beginning of the judgment, they explained the factual situation. I put some quotes here for you because I thought the way in which they framed it was quite interesting. Firstly, they spoke of the violent occupation by Israel of Palestine. They spoke about the war that the Israeli army is waging since 7 October 2023 against Hamas in Gaza and elsewhere, and that is described as a genocide, sorry for the typo, by various experts, also within international institutions such as the UN. So you see, the court is phrasing very carefully. The court is not saying the genocide that is going on. The court is really saying, well, there's this conflict, and some describe it as genocide. But then the court goes on to say, well, the facts are widely known, and it is impossible to escape the constant flow of information about the unthinkable atrocities that are incessantly taking place. So this was in July. As I said, it was an urgent application. So the application and the judgment, all of that happened in July. The applicable sets of rules were the Arms Trade Convention and then the Arms Trade Decree. This is a Flemish decree, which explains why the case was brought against the Flemish community, because it's under their competence. The dual use regulation was also used. That is an EU regulation specifically on arms and dual use items, because obviously ball bearings could potentially be dual use instruments, but the NGOs had really collected a lot of information to show that the likelihood was so high, of also with the company for which it was destined, that these are really the ball bearings that would be used in these particular tanks that are being produced. Various references to international law. So the court referred to the Geneva Conventions, the Genocide Convention. It referred to customary international law. It referred and quoted from the ICJ case that Israel, against Israel, brought by South Africa. It referred to the UN Special Rapporteur by Francesca Albanese's report, Forever Occupation, Genocide and Profit. It also referred to the arrest warrants by the ICC of Netanyahu and Gallant, and it referred to the specific resolutions of the UN General Assembly, the April ones, and specifically quoted the article, paragraph 14, on the arms export. So what did the court then do? Well, the court said that international law provides the context of this case, and the court said it is clear that Flanders is bound by international law. Okay. It said that the legal framework, being the weapons trade, and here the court then turned particularly to domestic law. Okay, because as I've said, we have this decree. So from the convention, the court really applied the Flemish decree, and looking into that, at what the obligations of the Flemish community is. It was very clear in that decree that there can be no license to export goods if it is clear that those goods are destined for a state that perpetrates genocide and infringes the Geneva Conventions. So this was a bit in dispute here, because the minister was saying, well, we have blocked temporarily the leaving of this vessel because we are inspecting whether they were supposed to ask a license. And here the NGO said, well, first of all, they do need a license. They cannot export these goods. And it's very good that very clear that the Flemish community cannot issue the license under the law, because it is clear that it's destined to Israel that is perpetrating a genocide and infringing the Geneva Conventions. Okay, so the court then said, well, if we have conventions and decrees and policies that are not converted into actions, then they'd lose all use. So in the end, the provisional measures were granted. The specific vessel was prevented from leaving the port of Antwerp, with also a penalty clause if they let this vessel leave. The vessel then did not leave the port. The subsequent developments are also interesting in the sense that the Flemish government said that it would appeal. There was then a huge public outcry, and people also commented in the newspapers, well, why are they spending their money on appealing instead of doing their job? They then backtracked and said, oh, no, we haven't yet decided on whether there'd be appeal. We were just debating that in the Flemish government. And then they said, okay, we will ask advice from a law firm whether they should appeal. They then got that advice from the law firm, and they kept on saying they're going to appeal as soon as the NGOs served the judgment on them formally. So this was a kind of limbo situation. And then on 15 October, well, actually the decision was a bit earlier, but this decision said that as of 15 October, there was a suspension of arms export and transfer through Flanders to Israel. This was a 6-month decision. So the decision was taken probably in September or early October to have it enforced as of the 15th of October. And what's interesting is this also followed apparently on discussions within the Working Party on Arms Trade in the Council of the European Union. So it seems that there is this monitoring body, this Working Party, and they get together every month, but their agendas are available online, but not the reports. And they have very interesting items on the agenda, such as information exchange regarding the arms export policies. So the Flemish decision states there that there's been an oral exchange of ideas, exchange of practices, but we don't know exactly what has been said there. Okay, that's from my side. Let me now give the floor to Gamze.
Thank you very much. And I'll go over. Yes, can you hear me? Well, okay. Yes, so I'll go over the next case. And that's in a French-speaking court of first instance in Brussels. As Thalia mentioned, it is against the Belgian state as such and not one of the federated communities. And it is a much broader case, so the applicant's claims are much broader, as I will go into it. But you can see here that, of course, there are different legal instruments, many international legal instruments, binding ones that bear on the case, including the Arms Trade Convention, the International Civil Aviation Convention, dual use regulation of the European Union, then that's a more supranational law. But there are also a number of references. So there is references to the provisional measures orders of the International Court of Justice in the South Africa versus Israel case, the genocide case of January, March, and May of 2024, the landmark advisory opinion of the ICJ on the legal consequences of Israel's acts and actions in the occupied Palestinian territories of July 2024, the arrest warrants of the ICC against Israeli leaders for their individual criminal responsibility, as well as UN General Assembly resolutions, particular reports by UN expert bodies, including the Special Rapporteur Francesca Albanese, that has been working really on this issue of economic ties, commercial ties, businesses, and other actors in relation to Gaza, and that particular report on from economy of occupation to the economy of genocide, as well as all of the different UN communiques by different specialist UN agencies. And there's also indirectly a Belgian royal decree from June 2024 to prevent transport of arms, which this decree also refers to the Genocide Convention and the ICJ orders. So what did the applicants request? Next slide, if you can. Yeah, thank you, Thalia. So the applicants really wanted to actually echo what has been voiced by a lot of civil society actors, a lot of also citizens, as well as scholars, academics, and other experts, that all arms, munitions, added relevant materials and technologies, including those for dual use, should not be transported or exported to Israel. So it's not just Belgian companies exporting these materials to Israel, but it's also the use of Belgium to transport. So it's also use the use of sort of Belgian territory as transit for these materials from a third country than with the destination of Israel. as well as the prohibition of all commercial exchange and investment. And this comes, of course, on the heels of the advisory opinion of the ICJ that clearly stated that states, third states, had a clear obligation to refrain from any acts and decisions that would allow for the illegal situation of the occupation to continue or to be legitimized by those dealings. And finally, for Belgium to unilaterally at least notify of its intention to denounce the association agreement between the EU and Israel, EU member states individually and Israel. So the applicants demanded that the court order the states to do the first two things, so the first two demands within 15 days of the judgment, and within 8 days, the notification of the intention to denounce. So basically, the applicants were asking the court to order the state to take these measures because they had, these measures had been demanded also at the EU level, but also in different national jurisdictions besides Belgium, in Ireland and Spain. So these are not just Belgium-specific demands. These have been voiced in other national jurisdictions as well. And what the court decided was quite disappointing, of course, for the applicants and in the general public, but that Belgium state had taken various measures. And so what the Belgian state had done was, although belatedly, it had raised the issue of the association agreement with the EU, mentioning that Belgium was in favor of a suspension, for instance. And so what the court said is, well, Belgian state has taken several measures. And as applicants, you haven't demonstrated that they had committed a manifest error of appreciation. What that means is, of course, there's this very famous, especially in the European context, concept of a margin of appreciation, saying the state may have obligations, but how it will discharge its obligations is a matter of policy. And so the governments tend to give in a margin of appreciation in deciding how they will discharge their obligations. And so the court's opinion on this was that basically Belgian state refusing to unilaterally adopt measures or to spontaneously adopt them did not amount to a manifest error of appreciation and a violation of its obligations. And so the measures that are chosen by the government, there's quite a large leeway according to the court, and that the courts, at least in the division of powers, so the separation of powers, the courts cannot impose a specific measure to be taken by a government. They can, in fact, but they can mention if something is being violated specifically. So what they were saying is Belgian state has obligations, so that was not contested. So all of the international law underlying those obligations was not contested. How those obligations would be discharged was left at the discretion of the state. And so we also wanted to maybe outline how international law in Belgium, so in the specific context of the country, of the state, is seen. Belgium, so international law is a part of the Belgian law. It can be invoked directly in courts. So Belgium has what is considered a monist system. So everything that comes from international law does not have to be transposed into Belgian law before being invoked in courts. And there's a sort of precedent, a very, very old precedent as well. And the courts can use international law directly alongside national law, but they are, so in these cases, things that are considered binding under international law, so court judgments, etc., were of course given that binding value, but UN General Assembly resolutions, for instance, were only considered to be recommendations, not binding, which this is in line with most courts, I would say, even if they're monist around the globe as regards UN General Assembly resolutions. And the courts are also, because of this balancing act, very careful to keep to the separation of powers, and they respect the kind of political rulemaking, and they stick to a very strict test of legality, a marginal legality test, and not a comprehensive test of whether those measures actually, within a, let's say, given time period, given the urgency of the situation, are in fact delivering the obligations, the content of the obligations. And in comparing the two cases, we tried to understand a little bit why this discrepancy. And of course, there were differences in strategy. So the first case that Thalia outlined was a really urgent situation with a vessel sitting in a port that could have really delivered materials that would be then used foreseeably in the commission of a number of international crimes. There was also a link to an existing domestic law legislation. So there was a decree, and the allegation was that that decree was not being correctly or sufficiently applied. And so the court then can judge whether that decree, in line with the international law obligations, is being applied in that context of violations that has been outlined. So the court does not challenge that. In the other court case, the court also does not challenge what international law is saying, but the measures that are being asked for are very broad, and it's not, the court case is not about a specific failure to implement a specific legislation, but it's more about what the state is doing or failing to do, as a kind of broad understanding of what measures it should take. And so the court is reluctant to test whether those measures are timely enough or sufficient enough in a broad sense, without having a very specific claim about why the timeliness is an issue or why the sufficiency is an issue. And so the court does not order the government to take a specific action in line with what the applicants say. And finally, what has... In our final slide, we wanted to look at how the development of international law, and as Raf was mentioning, international law is also to put it mildly, a state of crisis. It has never left its colonial roots, maybe, perhaps, and we're seeing the resurgence of, unfortunately, trustee systems and others. But there are also, of course, movements that can be used for emancipatory purposes, and so the courts do not challenge those parts of the law, at least those developments, like the ICJ cases, the advisory opinions, the ICC arrest warrants. The validity and the veracity of all of those are in a sense, not they are accepted, including also the reports by UN experts, including the special rapporteur on the OPT. And there is, but what we are seeing is it's not enough to have those sort of pieces of international law pronouncements without really enforcement at the national level. And at least in Belgium, the national courts have the option to use various sources of international law, which they have done. They've done it to provide context to state obligations, saying, well, the obligations exist. They haven't gone, and they can be invoked nationally. But in insofar as how they should be implemented, so when we go to the second stage of implementation, the courts have tended to look inward to domestic law. So it shows that there's a very clear interplay, and in the absence of specific laws that are putting in place those international legal obligations into domestic legal obligations and policy choices that are constrained by law, we see a broad margin of appreciation and no legal review of measures that may be in fact insufficient and not responding to the urgency of the situation, but we don't have a strong domestic legal enforcement option because we do not have specific domestic laws that buttress what we know through international law. So these are some of the challenges that I think legal professionals in Belgium will have to deal with going forward, but we think there can be also parallels in other jurisdictions. Thank you for your attention. It's, as usual, an honor to be among you, and we are very sad not to be there in person.